So thank you all so much for being here. As just a brief introduction, my name is Delbert Tran. I'm a Deputy Attorney General for the state of California. I primarily handle civil rights enforcement cases. So these are cases that the state will bring against different entities, private or public, that violate the civil rights of Californians. I also defend our civil rights laws. And so one example is a set of laws that California has passed, SB 826 and AB 979, which are laws that require California's publicly held corporations to have minorities, including Asian Americans, on their boards of directors. And that has been challenged in court, and I'm one of the lead attorneys defending that in our courts today. So it's very important for all of us to sort of know what our rights are, because while they may exist, they're nothing unless we're able to put them into effect. And so as we're here today to remember and commemorate the anniversary of the Atlanta shootings, we remember that we are here to unite against hate in all of its forms, against violence in our streets, but also in many of our other parts of our lives. And so this workshop is focused on the workplace, a place where many of us spend significant amounts of our lives pursuing our dreams, trying to eke out a better living for ourselves and for our loved ones. But discrimination can and does happen and thwarts those objectives. And so in order to combat that, here's a workshop to help us know what we can do about it. I'm gonna have to give a brief disclaimer as a lawyer we naturally have to do. I am here only in my personal capacity, not as a representative of the government, and I cannot give specific legal advice for a particular case. But as I'll mention later on in this presentation, SWAL, the Stand With Asian Americans community, has formed a community of individuals that you can connect to, that can give resources and referrals to lawyers if you have a case that needs to be brought. So recently in December, Stand With Asian Americans launched the Workplace Justice Initiative. And so this is a reporting portal on our website that allows individuals to share the stories of what they experience so that people know that they are not alone. It is the story of our own organization. As our founder, Justin Zhu, has many times explained, he himself, as the founder of a startup, has been the victim of anti-Asian discrimination in his workplace. And it is the story of so many others as well, and many, I'm sure, in this community. Now, historically, when we think about our rights and the laws that protect them, the main law that often comes to mind is the Civil Rights Act of 1964. Passed after the African American Civil Rights Movement, there was a major moment where the United States enshrined a law protecting individuals from discrimination, including in the workplace under Title VII. Now, to many people, this was the page being turned in history, an end to prejudice. Of course, we know that's not true. The Civil Rights Act did not end prejudice, but it gave us the tools to fight against it. So there are many things that the Civil Rights Act of 1964 and other laws, both in state and federal, protect against. So these are the many categories that are protected from discrimination. Not only race, but things such as national origin, ancestry, sex, disability, all of these are covered and protected. And thus, the breadth of these protections are necessary to make sure that other forms of discrimination, however subtle, can be stopped. And so, for example, think about a colleague that might have recently immigrated who is Asian or Asian American. The fact that English might not be their first language, if they are mistreated because of that, that is still a potential grounds for discrimination. The fact that they may be camouflaged as a language bias or as something else does not stop it from being discrimination, however linked to race or ethnicity it might be. So there are many categories here. The other thing I want to note is throughout this presentation, I'll often list two sets of protections. There are protections under federal law, and there are also protections under California law. And what this means for those who aren't familiar is that in our system of government, we have two overlapping systems of law. And so if you're wondering, well, which one applies to me in my situation? Here in California, the answer is both. And that's the benefit of living in a state like California, where we take a progressive stand on fighting discrimination. Oftentimes, California will have even stronger protections than what exists in federal law. And so as you can see in this slide, not only does California protect all the categories on the left column, in addition to those categories, California protects these other parts against discrimination as well. Now, There's also the question of who receives these protections. Now, these laws are pretty broad under Title VII, whether you're under the federal law or whether you're under the federal employment, the FEHA Act under California, which is the equivalent under the state side, but it protects employees, temporary workers, job applicants, even former employees. Now, one difference here between federal and state law is that federal law does not protect independent contractors or people who are not paid, people, for example, like volunteers. California law is different. It protects volunteers, it protects interns, even if you're not receiving a paycheck. Next, what kind of companies or organizations are covered by our anti-discrimination laws? Both sets are pretty comprehensive. They cover public employers like the government, they cover private employers, they cover labor unions, or even employment agencies, for example, those that might refer people for temporary or contracting assignments. So these are a pretty broad set of applications. One thing to note is that there is a threshold that a company has to meet to be covered by these laws. So when it comes to federal anti-discrimination laws, those apply to corporations with 15 or more employees. So if it's a startup with 5 individuals, federal anti-discrimination law would not apply in that circumstance. But again, we're lucky to live in California because California's laws do apply in a broader sense and apply to any employer with 5 or more employees when it comes to anti-discrimination violations. And there's a separate violation that can happen, which is harassment. And there, California law is even more permissive. It applies to pretty much all employees. Now, there are a number of things that can be caused by discrimination in the workplace. We often think of firing and pay, but there are a broader set than just those things. Your benefits are also subject to protections under anti-discrimination law. So for example, if you're requesting retirement benefits, or perhaps it's a tech company and stock shares, and you're realizing, hey, how come I don't have the same stock options as my non-Asian colleagues? These are protected as well. And so it's important to remember that employment discrimination doesn't just happen when you're fired, it doesn't just happen when you're denied a job, but also happens to the whole range of benefits that you get when you're in your job. And this even includes things such as your assignments. If you're not getting the premium assignments that give you experience that are necessary to advance in your role, that if they're essentially tracking you, for instance, on lower rewarding work, that can be a problem as well, and that can be grounds for discrimination. One thing I want to highlight here is that harassment is prohibited under our anti-discrimination laws. The harassment standard, however, is pretty broad. It requires the harassment to either be a condition of your employment, that is, your employer basically tells you, you have to deal with this or we'll fire you, or the harassment has to be so comprehensive that it would materially change the conditions of your work. And so just to give an example of an unfortunately terrible ruling by a court, there have been some cases where individuals have pointed out to a court, people in my workplace have used offensive names to reference me as an Asian American. There was a case in the Ninth Circuit, which covers the West Coast, where a person pointed out that her employees had done the slanted eye gesture at her, and that they had made fun of her pronunciation. And she claimed that this was discriminatory harassment. However, the court said that was not enough to constitute harassment because those were only 2 incidents within the scope of 2 years. So when you're talking about harassment, the courts are looking at something very specific and particular. They're looking at something that happens repeatedly and something that changes the way that you experience your workplace environment. So the repeated part is something I'll emphasize when we talk about what you need to be aware of, thinking about in terms of evidence and what constitutes evidence of discrimination. So let's say that you are in the unfortunate situation where you have to deal with discrimination. What are the steps that we can do? What rights do we have? So number 1, a little self-serving, but I'm going to say join the Stand with Asian Americans community, join the Workplace Justice Initiative, share your stories so that we all know that we are not in this alone. But also, in addition to those stories, we have a Slack community where people can not only communicate with others who've gone through similar things, can share information about workplace environments, but also refer each other to resources. So in addition to reporting incidents, the SWA website has a number of resources for employees, basic tips on trying to advance in your role and learn how to navigate the politics of a workplace environment. We also have mental health resources to deal with, of course, the trauma and stress of dealing with discriminatory events that you'll experience. And there are individuals that can refer you to lawyers and other employment specialists who can deal with specific cases when you need it. The next step, however, once you've gotten connected with the community, learned what steps or resources you might have is, let's say you have to deal with it. This is a problem in the workplace, you have to take action. I'm going to now cover the several steps you can take under the law. So the first legal step that you can and often have to take is to file an administrative complaint. So there are two different agencies that handle these complaints. There's a United States Equal Employment Opportunity Commission, the EEOC. There's also the California Civil Rights Department, which is their equivalent on the state side. And so what these organizations do is that they specifically deal with employment discrimination cases. And so if you are experiencing workplace discrimination, they are places where you have to submit a complaint in order to bring a legal claim. They have lawyers, they know the standards under Title VII and the various laws that apply, and there are various rules that you have to keep in mind when you submit a complaint to these organizations. So as you can see from these slides, there are certain deadlines and certain limitations you have to keep in mind. If you're filing a complaint with the EEOC, it has to be 300 days after the act of discrimination has happened. And that timeline is strict. If you come in 301 days after discrimination, by law, they cannot accept your complaint. And so this is an important timeline to keep in mind. So that's why it's important to know in advance, because you don't know when these situations are going to come up, and when it does come up, you need to know what your timelines are for when you should act. Next, in the process, you'll submit a complaint formally through online websites. You can check the EEOC website where you can submit a complaint there. You can submit a written complaint through the mail, or you can call the EEOC and you can talk to someone there and submit an oral complaint, which is the process. Now, when you submit a complaint, there will be someone within that department that reviews and screens the complaints. So it's possible if your application was late, if it was not within 300 days, that they would simply not conduct an investigation because the law prevents them from doing so. Or alternatively, you might be complaining about a rights issue that is not covered by employment law, but maybe a constitutional rights issue. Maybe if you're talking about your free speech rights, that might be a context that where they say, well, maybe this is a different thing that a different agency handles. So there are some things that they do not handle. But when it comes to workplace discrimination, the things we talked about, hiring, firing, getting benefits, whether or not you're getting treated differently from your coworkers, that is something these agencies will investigate. Now, the average time of investigation varies. The 2020 annual report from the EEOC states that it took about 200 days on average for an investigation to complete on their end. The California Civil Rights Department, for its part, has to complete its investigations within 1 year. So that's just a general timeline to be aware of when you're submitting a complaint. There's also voluntary mediation, where both agencies offer free licensed mediators to help make negotiations informally between you and your employer if both the parties agree. So this is an option made available to you by both the EEOC and the Civil Rights Department. It's not required, though, necessarily, if you think this is not something we can negotiate about. You know, this person's been saying racial slurs right to my face after I told them to stop, and there's no negotiating around that. You don't have to do this process. This is only an option if you'd like to use it. Then afterwards, there is a conciliation process, which is sort of parallel across both agencies. And that's just the name for how they try to structure a settlement. They try to come to a settlement with you and your employer that's bound in some sort of written agreement. If, for whatever reason, they find there is a discrimination violation of laws, but the employer is unwilling to agree to a settlement, then the agency may bring a case in court. And so, again, these are all civil rights lawyers at these agencies. Their goal is to help you. And so if you have questions, they're certainly happy to help. Then they're going to try to do their best. But then again, at the same time, they're government agencies, which means there's a high workload and volume. So because of that, as I mentioned, timelines can take a longer time in some instances for them to complete the investigation and come to a determination. And then one part of this that is important to keep in mind is the reason I'm talking about the EEOC and the Civil Rights Department first, instead of talking about courtrooms, is that our civil rights laws require, before you bring a lawsuit in court, to first file a complaint with an administrative agency. So if you have experienced discrimination, you're frustrated, it's damaging, you've lost pay because of it, if you bypass this process and decide to file a lawsuit immediately, the court is going to kick you out. They're going to say the law requires you to first exhaust your administrative agency options. Once you've gone through this process, whether or not the agency takes action in your favor, if they say nothing we can see as a violation here, they will issue a letter saying you have a right to sue. That's when you know you can then bring your claim in court. Now, I mentioned earlier there is a time process for these investigations, and maybe you're thinking, this case is so clear-cut, I don't want to wait 200 days for this to resolve. I have something very urgent that needs to be solved right now. Another option is to demand the right to sue letter immediately. So what you'll do is you'll submit a complaint to one of these agencies, but you'll include in that complaint, I don't want to go through this lengthy investigation process, just give me the right to sue now. And in most cases, the agencies are happy to do so because they have a lot of things to balance and they know that individuals want to bring their cases, they're happy to let you have your rights to bring in court. But you need to have that right to sue approval before you can bring that case. So let's say you've gone through this process, you've gone through the agency, for whatever reason, the agency is not able to help you in the way you need, then it may be time to go to court. Now, when you're going to court, as I mentioned, you have to fulfill this administrative process, but the specific requirements for filing in court will depend on your case, and this is where you need a lawyer. You need to consult with someone and have that specific legal advice for your case, depending on whether you're filing in federal court or state court. What's good to know about California is that the right to sue letters that are given to you after you filed a complaint cover both sets of courts. So the Civil Rights Department of California and the federal government have come to an agreement where if one person files a complaint with one agency, that gives you a right to sue in both courts. You don't have to file separate complaints for federal and state courts. That single complaint will give you access to both federal and state court, whichever is better for your case or whatever is more convenient based on what you've consulted with your lawyer. So once you've gone to court, you now have to prove your claims of discrimination. Now, discrimination under our laws are protected under an area what's known as civil law, which is different from criminal law. The main difference between those categories is that criminal law is a set of laws where the violation results in someone going to jail. Civil law covers everything else. It requires fees and fines and penalties for employers that will cover in the workplace discrimination context. The burden to prove your case in civil court is different than in criminal law. If you've watched, Law and Order, you might have heard the standard of beyond a reasonable doubt to prove someone's guilty. That is only for a criminal case. For a civil case, it's easier. All you have to prove is by a preponderance of the evidence that your claims are correct. And that just means more likely than not that you have suffered discrimination. The other thing to think about is what you need to prove your claim. It's not enough that you've suffered something bad at work. If you have a terrible boss who's been abusive, who is hostile, who yells at you and says derogatory things about you, that alone is not enough unless it's motivated by discrimination. There has to be something linking that treatment to you because of your race, because of your ethnicity. And so in some cases, there's direct evidence of that. You have cases where someone has directly said that horrible thing about Asian Americans at the workplace. So one example of this, there was a case in 2000 where at the University of California, Davis, there was a professor of pharmacology who brought discrimination workplace lawsuit. And he was denied a full-time role at his university where literally there was a conversation with the dean where one of the administrators said, 2, quote, chinks is enough in our department of pharmacology. And in another time, when he demanded that he be entitled to his promotion as he had been requesting, he was told to pray to your Buddha. So these are very obvious examples of statements reflecting discrimination based on race. Now, if they had been simply terrible people, if they said, 2 professors are enough, we don't need another one. If they said, well, pray to your God instead, that would be different. It would be harder because they wouldn't have that proof of direct racial terminology. The difficulty with these cases is that they're all fact dependent. There's no checklist that will say this is a case of discrimination. And so because of that, every court will look at each situation differently. In some cases, in most cases, you won't have that direct evidence. Some people are either clever enough or simply subtle enough that the things they say won't be as directly, explicitly racist. That said, there are still ways to prove that they've been acting in a discriminatory manner. And so some of the things to think about, how have they treated you compared to people who are not Asian in similar roles? How have they followed their rules and procedures that would ordinarily apply in these companies? What are they doing and what are they being motivated by are important questions that the court will be asking as they review these cases. And the important theme that we've raised so far in this event commemorating the Atlanta shooting is that we stand together. And often when we think about our rights, when we think about lawsuits, we think about them individually. We think about one person filing a lawsuit. We think about one person's individual rights. But as we sort of reviewed right here, one person alone isn't enough because you need the evidence. You need the comparisons. In that case I mentioned with the University of California, one piece of evidence that the court relied upon on top of the racist statements was they looked at all the other professors in the workplace. And they looked and noticed all of the white professors got that promotion, but not the Asian one. And so when we're thinking about our rights, it's important to stay open not just to the harms that we suffer, but our other Asian American and other minority community members too, because we can provide the information that shows and reveals that something different is happening here, that we or they have been treated differently, and that when that happens, we can speak up. One of the things that's protected earlier under anti-discrimination laws is retaliation. Things that employers do to punish people for speaking up about their rights, for filing a complaint, or participating as a witness and giving information, those are forbidden by law too. And so it's important not to be afraid of the repercussions because these rights are protected and that retaliation is impermissible as well. So I'm gonna pause for a moment, see if there are any questions from the audience that I can help answer. As a quick caveat again, I can't give specific legal advice for a particular situation, but I can give general information about the laws if anyone has any questions. Yeah.
So I read it on the internet that Gavin Newsom helped pass a law, I think it was in 2022 or something like that, that if he signed a non-disclosure agreement, but then if your complaint was regarding discrimination, harassment, it doesn't apply. Could you talk a little bit about that? Do you know anything about that?
Yeah, I don't have the specific citation off the top of my head, but non-disclosure agreements do have limitations. They're contracts, and contracts are normally binding, but they're not absolute, right? You can't sign a contract saying, I will kill someone, because that's illegal. And so I think what that law is directed towards is that there are illegal conduct that cannot be protected simply by an agreement. And so, again, this is a specific circumstance question. It depends on the nature, the text of the NDA itself, but I think there are many situations like that where discrimination claims can still be brought. Yeah. Yes?
Immigration status protected in California, but not federal, or is it protected?
It's protected in both, and I can go back to the slide, but one of the categories is that both sets of laws protect is also, they protect undocumented workers. So immigration status is covered within national origin and alienage, and it's again an important area to protect because many employers will often try to create double standards, right, for different employees if you're here on a green card, for instance, or something like that. And so that is an important protection that is included under both federal and state law.
So when you talk about like verbal harassment and things like that, is it hard to prove, like that they're actually if it becomes like a he said, she said kind of thing, where they couldn't said it, would you have to record like those conversations, things like that, you know, publicly happens?
Yeah, it's a very difficult situation to get not only have that incident happen, but the evidence to procure it, because if it's a verbal conversation, it can be that sort of situation. So that's why, as a matter of practice, if you're in a situation like this, it's very important to take written notes to contemporaneously, log the things that happen. Another thing is if this occurs over written emails, to save those emails and to be mindful of having those documentation. This is why witnesses to corroborate are very important. If this is a conversation with multiple people, it is essential to have another person to help corroborate that, because the standard that is usually applied in these discrimination cases is sort of a burden shifting. So first they say the plaintiff, the person suing, has to have an initial case of discrimination, and then the employer can then rebut it. And if the employer says, no, that's not what actually happened, then it's your burden again to say, no, they're the ones wrong. Because ultimately, if it's a 50-50, the person suing loses. You have to prove that it's more likely that your claims are true when you're in court. So having witnesses who will corroborate, writing down and documenting everything that was said, keeping any written communications corroborate, those are most important. And the last part of it is that there's no truth serum, right, that can force someone to tell the truth. But if you do have a case, there's a process of interviews, of depositions in which people are required under oath to tell the truth. And that can be a lot of pressure and an important way to make sure that they're telling the truth about what actually happened in these conversations. Yeah.
If you happen to record the incident, is that admissible in court, or do people on the tape or the video have to give consent?
Sorry, when you're talking about a tape and you're recording, right?
No, I mean, it's asking, are you allowed to record it? Right, let's say one of the evidence comes in, another coworker took a video, on the mobile phone, right? So do the people on the video have to, consent to be recorded for that to be admissible as evidence in court?
So it depends. If it's purely like a phone call conversation, and I know it's a very lawyerly answer, there is a law that prohibits, unconsented, recording in California. But if you're in a public context, let's say you are in, in this ballroom at a public event, and this conversation is happening, then those limitations don't apply. So it can depend on a particular case where the setting is, if it's seen as something public. And so one example that comes to mind of a case I recently looked at, there was a teacher being recorded in class by a student. And they challenged that under the lack of consent to have that recording. And the court held that no, because you're a teacher in this public environment, you're at school, teaching a whole group of people, that's a public setting where that law did not apply.
But let's say in a private office, and one of the coworkers reported the racial.
So it gets very tricky once you get to very specific context. That's unfortunately why I can't give specific legal advice for that situation. But I think when you have that consultation, or the EEOC or the Civil Rights Department contacts will be able to help sort of drill down on those specific questions and help out in those circumstances. Yeah, and back.
In an example that you gave earlier, I think it was about the pharmaceutical professional who wasn't promoted, whereas their white colleagues were. I'm curious to know, when you bring a suit about, is it the responsibility of the person who is bringing the suit about to find that information and everything, or is there any kind of obligation placed on the institution or the organization that you're bringing the suit against to disclose that information as to who has and hasn't been promoted?
Unfortunately, it's the plaintiff, the person bringing the suit, who has the obligation to present all those documents to the court. But there are tools during litigation in which a plaintiff can request documents from the other side to turn over all the promotion records and things like that. So you have to bring all the evidence to present your case, but there are ways to get that from your employer or from the individual or organization you might be suing.
So if you were to bring about, go through that process and everything, and the organization deny your request, would that just kind of be dead in the water? Would it be telling of their intentions or motivations in any way? Or would there be any sort of power aside from the plaintiff's efforts to compel them to disclose?
Yeah, so we're getting pretty nitty-gritty into litigation here, but in discovery, which is Yeah, totally. I mean, it's because this is what you need, right, to know. In discovery, this is the process where you call the whole period in which you collect and present your evidence. If you are denied the discovery you request, you have various tools such as motions to compel, where you can file an argument before the court saying, I'm entitled to this information, they've denied it, I know it exists, but they haven't given it to me. And the court can force them to give it over. There are some cases where they might claim, we don't have it. And you might believe, like, no, I really know it's there. In some cases, if the motion to compel doesn't direct them to produce it or doesn't like result in the document being produced, the courts can sometimes take an adverse inference in which they say, well, this document was supposed to be there, the employer says it's not there, so I'm gonna assume it says the bad thing that the plaintiff is saying. So there are some penalties if the document is not prepared or produced. But it depends on you being able to show that there is a document that you should be receiving. If you're unsure, if there's like a general category, you might not be successful. So knowing the specifics of what records there might be is very important in getting these documents. Mm-hmm. Yeah.
Yeah, I just want to thank you for providing that example of professors, because that's really helpful to hear. And I just want to give, however this helps anyone, but I had was let go at a company, and I felt that was I had some kind of discrimination for that. So I consulted an attorney, and after I provided all that information, he's like, I don't think we can have a substantial case. And he's like, oh, well, can you think of something else? So I said, well, I worked for very long hours on the weekend, and then he used that case instead, because I do some things that I'm not a licensed professional. So I actually was successful in that. So I was happy about being successful for having something else against them, but I didn't really, I didn't have enough evidence to support how I felt.
Yeah. Thank you so much for sharing that, and I'm sorry you had to go through that. I think that sort of reveals one of the challenges in bringing this litigation, that because it is very fact-dependent, because courts don't have a checklist or a one-size-fits-all sort of way of deciding, that makes it very hard for that employment attorney or other attorneys to think like, well, to have certainty that they will win because they don't know how the court will look at the whole situation. You have the UC Davis case I just talked about, or you have the other case where the court concluded it was stray remarks that did not constitute harassment. So there's variation in how the courts handle it. But one thing that can help is that as lawyers and as courts, the rulings are always precedent-based, which means they look at previous decisions to inform how they make the decision here. And when there are more decisions and cases that lay out specific circumstances where discrimination has happened, it gives more grounds for a court to say, this is a clear case of discrimination because something like this happened before. And I can speak to that as like experience because in my own litigation, when we're defending California's corporate diversity laws, the reason we defend it is because it has to exist to fight discrimination. And the reason we know there is discrimination is because so many people have said these terrible statements that have been told to them in the workplace, and look at all of these cases where courts said similar statements counted as discrimination. And so it's very important to have that precedent if, of course, you have the resources and the ability to do so. But it can be very challenging, and that's why, of course, SWAL tries to provide a community so that you know you're not in this alone to help you as you think through this process. Sorry, I don't think you have asked a question yet. So.
One question. How can pursuing litigation affect future employment?
So that's a great question, and it's often a practical fear, right? You don't want to be sort of ostracized as like a troublemaker. But again, retaliation is protected under our anti-discrimination laws, and that includes retaliation in future employment as well. They can't deny your application because you had a previous suit that you had filed, because that's your right. Of course, the issue is making sure that employers don't behave this way. It's hard to know beforehand whether or not they'll follow the law if they don't disclose their thinking. And so part of it is a culture change. We have to make sure that people within these companies are aware that we create this culture of accepting and recognizing these rights are violated. and that this culture spreads to people who are making those decisions, to the in-house counsel who advise these decisions, to make sure that they remember their responsibilities. But again, if there's evidence that someone said, let's not hire him, he filed a lawsuit because of discrimination, that would be a violation of your rights, because that is your right to do that.
Well, I want to piggyback on that, because why would you want to work at a company that does that in the first place, right? So why would you do that? Number one. Number two, my understanding is there's like on the phone apps, there's recordings. Like there's a phone app when you can call and you can record the conversation. So as long as you tell the other person, saying, hey, this conversation is being recorded, that's okay, right? That could be included in it, as long as both parties know that the conversation is being recorded.
So the statute requires consent, and so in most cases, you've probably been on some sort of hold line with a company that you've been calling, right? And they'll give you a little pre-recorded message saying, this message is being recorded for whatever training purposes, et cetera. That is to give you notice, and implicitly by staying on, you're consenting to that notice. But if you're on a call with just a person and you're saying, hey, I'm recording you, and they say, no, don't do that, that would not be
But
usable.
if they say okay,
Yeah.
that's fine.
Mhm.
Okay, so I just want to let people know, even if you're like in a conversation in a room, and just say, I want to record this conversation because I want to be a record, and as long as the other person consent, that's okay, right?
Right.
So that includes phone calls.
Mhm.
And the phone apps, they have those now. So.
Yeah, thanks so much for pointing that out. I think there's a question in the back.
If you file a discrimination lawsuit, you're the plaintiff, right? So that becomes public record, right? In whatever courthouse. So in San Francisco, it would be a civil matter filed at 400 McAllister, and then once the case is filed, your discrimination lawsuit is filed, it becomes public record. So it can be like done with a simple like internet search. Like if you Google your name, it'll show up on the internet, So how do you, what is the word to close the, get it out of public record, get it out of public view? What is that called?
You can seal certain court records. In an employment case, it's not going to be an option I think that most courts will do. Sealing is often reserved for cases. It can involve individual, let's say it's a minor. There's people under the age of 18, they protect the privacy. There are specific legal requirements that allow for the sealing of cases. If it's there can be some rare like national security cases where they might seal. In the case of an individual employment case, it is harder, but again, these are things that you can request of the court. And if you have a good enough case for it, if there's a lot of publicity, a lot of blowback, if you've experienced threats or retaliation that you can substantiate, then that can be things that you can point out to the court to tell the court why this case needs to be sealed.
It's always a civil matter in terms of an employment, like discrimination case, unless you have something like workplace violence or something like that, and then it crosses over into like a criminal matter, and then that wouldn't be filed in the civil court, it would be filed in a criminal court, and that's a whole other realm of law. Yeah. So,
Right, that's right.
Okay, thank you.
Mm-hmm. Do we have any other questions? Oh, yeah, that.
You have to look at how similar employees are treated other employees of a different race, for example. When you request that during discovery from the employer, should they use privacy as a reason to deny your request?
So the privacy can be a reason to limit some information, but it cannot be a reason to block that specific information. So they can, block out if there's social security numbers on different documents, even maybe personally identifying information like names and addresses, things like that, but they cannot prevent you from getting the whole thing entirely because it's part of the claim. You have to prove a claim, and in that comparison, things about an anonymous other person who is not Asian would not be private because there are ways to, redact documents to give them but still protect privacy. So something like salary, again, could be shared if like what you're claiming is I'm getting paid less than my other coworkers who are doing similar work. That is something that could be shared. If it is private information, if court treats it like that, what they will do is just hide the information about who that belongs to, right? That they'll take out the person's name, they'll take out address, and otherwise, this is this unnamed person who does a similar job, and they'll compare salaries, something like that. Okay.
Related to that, related to privacy and retaliation. So I saw these postings recently from a lady who said she thinks she got drugged at a company party, and she got fired, and she tried to file a claim, and then she posted this email from the company saying, hey, there were internal investigations, you were the one who sexually harassed the male, and if you keep going through with this internal investigation or whatever will become public. Do you want that, right? So I'm just wondering so let's say you bring up administrative complaint or what have you, like at what stage do the details become public, and to what level of detail will they include internal investigations which might not be corroborated? Like, will that be there, or is it more like a summary of the case?
Yeah, that's a good question. I think that's
A company party. That's crime.
yeah.
Yeah.
It's very troublesome news, but to your question, first, I think that internal investigation that is being referred to seems like it was the company's internal one, not one done by one of the agencies. If you do file a complaint with the agency, the employer or the subject of the complaint will be notified of that complaint 10 days after, so that will be information they'll be aware of. In terms of the procedures for the complaint, the investigation conducted by the government will be mostly confidential because they don't want the information to be corrupted if people are sharing notes, for instance. So they'll try to keep it discreet, but the fact of the investigation will be established and known. It will be public.
Equal rights advocates. Look it up. They do free legal assistance for exactly those type of issues in regards to what you're describing is called a drug-facilitated sexual assault. Is that what happened?
Not to me, but to this lady
Right.
on LinkedIn, she was
Right.
mentioning it.
It's very common.
Yeah.
You should file a police report.
Thanks so much for that referral. This is why it's so important to be part of the community. We have all these resources and information and knowledge we can share with each other, so thank you.
So someone was mentioning some indirect way of doing things. So if, let's say like a person never went to the courts or filed a complaint, but he tried to go to HR internally, right, and say, hey, these things are happening, right, and we're getting sued billions of dollars, we're losing billions because of certain pricing strategies and what have you, and certain racial words were used, but the main thing is, you hear from another boss, an ex-boss, that people in this company, maybe it's not official, but they have a talk, right, and say, hey, don't work with this person in the future, right, this is what we think he did, right, and is there anything how frequent do you think is that kind of case where people, instead of going through the official routes, people try to retaliate by using some old voice network or is it pretty common?
Well, I don't have any statistics here off the top of my head, but I think that's probably a very common situation because the things that we're combating here, discrimination, prejudice, bias, these are things that happen both formally and informally, right? People are doing it through official channels, but also through their little talks one-on-one and their sort of huddles together. The Old Boys Network is something that has been actually referenced in multiple court decisions as something that exists and does affect many people when they're bringing issues of discrimination up. So yeah, I think it is something that does happen pretty frequently.
But you can't always trust them to help you.
No,
Yeah, as you know, they've never protected themselves.
Yeah, they want to protect their own company.
their jobs.
Yeah. They're definitely equal rights advocates. Look it up there in San Francisco. Yeah.
We have another question up here.
It's not a question, it's more something I wanted to share with the group. So I worked in HR for over 25 years. Let me just reiterate, HR is not your friend, okay? They work for the company, they're there to protect the company. So it's like, if you're trying to get help from HR, not a good idea. at the end of the day, it's a lot of mental anguish trying to fight the system, especially when you're working for a large firm, because they have a huge legal department and you're just one person. So my advice, take it or leave it. Don't put all your eggs in one basket. Network, network, network. Get to know people at settings like these. Gain trust, because trust is something that could be lost like that, And so, why would you want to work at an employer where they're talking to each other about you, right? Why? You don't want to be there anyway. You want to be at a place where they embrace you, they value you. If they don't value you, get out. And then just talk about them on social media.
Yeah, is there a question?
Kind of following up to this
Mhm.
question, let's say, so, you take this lady's advice and say, okay, well, leave this company, go to a better place. You're interviewing and then you're not getting interviewed, you're not getting hired. But how do you know if those companies are trying under the table? They're not openly, they know, oh, okay, because you check Asian, you check woman, you check whatever on the EEOC part of the application, that you're not discriminating there, there's no way to track how do you deal with that?
That's one of the hardest challenges because discrimination can often be hidden, and the law cannot necessarily open up everyone's hearts to the public. And in those situations where they don't tell you, where they're silent, where there are harms not through words but through omissions, it can be very challenging to deal with. And I think it's a reminder that the law is a tool, but it's not a perfect tool. It's one way of addressing these, but that there are many others that we need to push through the community, through our networks, through our connections to learn about these things that when they happen, or to influence the companies themselves to prevent them from making those harmful decisions in the first place, to things like having ERGs and other advocacy groups within workplaces to make it a better workplace for everyone, to make sure that those things do not sort of pass by unseen. But it is very challenging, and that's the hardest part often about being a lawyer, is that there are things that you suspect very likely happened, but when it's not said, it can be hard to really substantiate before a court. But the good news, maybe silver lining I'll put it, is that with this very virulent culture, hate has become emboldened, and it also has become stupid. People say the hateful things out loud, they are proud of it, they're unashamed, but that gives them more to target and fight back against. It gives them the words to sink them. And it's an unrelated set of cases, but this is sort of human nature where people often find ways to express these things. In the voting rights cases, just the context in the context of gerrymandering, there's a famous conservative strategist who told all of his government employees, do not put anything in writing. He would have PowerPoints like this, all bold, do not put anything in writing explaining that you are gerrymandering based on race, that you're gerrymandering based on X or Y factors. Countless cases found that presentation and everyone wrote down. So despite their best efforts, people still let slip. The mask slides off and you can often detect it. But it's still important that we stay vigilant and that we know our rights and that we can combat it whenever we see it.
Kind of follow up with that, maybe you're the best person. So if you're applying for a position, should you decline the state of the racial or veteran or medical, gender? Should you
I mean,
say
it could go both
no?
ways, because they'll be like, if you don't answer, they'll be like, where is this person hiding, right? And then if you're saying it, they're like, okay, that person's Asian, what have you. So I mean, I think it's at the end of the day, what I've learned, just working in corporate, like Fortune 500 companies, is that they don't like smart people. They like people who say yes. It's just like if you own a business, you want people that's gonna make your life easier. Even in a marriage, right? You want to be with somebody, any relationship, friendship, romantic, you want to be with somebody that's going to make your life easier. So if you become a problem, you're going to be a target, and you're going to be under blacklist, and they'll get rid of you. So, and at the end of the day, why would you want to be in that environment? So I think one of the other thing is entrepreneurship. Like Asian people, we come here, we open these restaurant stuff, and then you want the kids to go to become doctors and lawyers and, you know, go into corporate America. Well, you know what? Let's start our own business. I mean, that's what the foundation of our country is, creativity and bringing all these different cultures together. And think about, okay, what do people actually need? You know, the other day I was thinking to myself, oh, it would be nice to have a biodegradable, compostable dog poop bag. So I'm working with a company to come up with that. Because right now at Whole Foods they only have one, one type, right? So just come up, like what is the need? And then there's Amazon. You don't even need a store to sell things in. You don't need to pay rent to have a store. So again, don't put everything in one basket. Have different sources of income. Whether it's real estate, there's a program called Aspire. I just went. It's a 2-day program. They had Joe Montana there. And you know those guys from Shark Tank? They're all there. And they're like, don't listen to your parents who are broke, right? Like, listen to us. This is what we do. This is how you evade taxes. And they teach you how to make money. And what they're saying is surround yourself with people that you aspire to be. Don't hang out with broke people. You know, because your parents may be blue-collar worker. They work, you know, 40, 50, 60 hours a week, you know, overtime. All they do is save, and they recycle all your, you know, Ziploc bags. You know what I'm talking about, right? I mean, it's like, no, I don't want to be like that. I want to be the Shark Tank guy, you know? So that's what I mean. I mean, the law's great. There's protection. But we got to think outside of the box. We got to be creative.
Absolutely.
Right.
And in this city, San Francisco of innovation, and for Asian Americans whose so many families have come here and had to build a whole new life, to be entrepreneurs on the spot, I think that is the spirit that we have to take initiative. Whether it's starting these organizations or taking leadership roles to prevent these from happening, or taking the initiative to call out discrimination when it happens, it's important to be there, to stand together, and to speak up.